Welcome to Metro Talk. I'm Kent Shuffle. Thanks for being with us. Jim Schrader's here. Jim's the publisher of the Telegraph. Welcome, Jim.
Hi, Kent.
And Pat Gowan, one of the editors with the Post-Dispatch, is alongside as well. Welcome, Pat.
I can't.
Pat, attorneys for former Governor Rod Blagojevich have asked the judge in Blagojevich's trial to put the former governor in a drug rehab program when he goes to prison. Does the former governor really need a drug rehab program? Is there an issue there we haven't heard about, or is this an effort to get a lighter sentence?
Well, you can get a lighter sentence in the federal system this way. You can get a little time knocked off if you participate in a rehab program if you've got a problem in the first place. Blagojevich is a man of many problems, but I have yet to hear anyone suggest that he was on drugs, although it might explain some of his behavior through the years. The judge has recommended it. It will be up to the Federal Bureau of Prisons ultimately whether really to do it. And if he participates in a program, it could knock maybe a year off his sentence. Scott Faywell, who is the chief of staff for Governor George Ryan, both of those men went to prison. Ryan's still there. Faywell said it was well known that you could get time knocked off your sentence for drug abuse, and has suggested, I think, that some people have gotten into the program with a claim of drinking as few as 5 drinks a week, which probably 5 alcoholic drinks, of course, a week, which probably qualifies a whole lot of people. And hey, a year is a year. So, and maybe it gets you better housing, I understand, or more segregated housing. It gets you a lighter work detail. So there probably are some advantages to it if you can prove to them that you're a drug abuser. Now he's gotten his sentencing delayed until March 15. So maybe between now and then he can connect up with something that would give credence. I mean, it would be an incentive to go out and become a drug user, I suppose. Bizarre as that may sound, it would be absolutely harebrained. As a matter of fact, harebrained is a good word, because you may have read in the news on the day we're taping this that now the lawyers have gone back to Judge Zagel and asked him for some consideration for a mistrial or juror misconduct case against one of the jurors because she spoke out at a civics class about her experience as a Blagojevich juror and showed, I guess, a juror questionnaire that had been filled out, and they were claiming that this was improper. Well, it's never been improper to my knowledge. Once you're released from jury service, you're free to talk about any part of it, which is, by the way, what the judge said, along with calling the lawyers harebrained, and suggested that they had not done their homework in bringing that motion forward, and also suggested that the lawyers ought to apologize to the juror, whom they seemed to have cast aspersions about when the woman had done nothing wrong in the first place. So harebrained. I haven't heard that term applied to Blagojevich yet, but it seems to fit pretty nicely.
Jim, attorneys for former Governor Blagojevich say that he should enter a drug rehab program when he goes to prison. Is there a problem here we haven't heard about, or is this an effort for a lighter sentence?
Well, what you guys may not be aware of, there is a little-known addiction to Rogaine that makes hair grow.
I certainly am unaware of it.
And apparently, former Governor Blagojevich has developed an addiction to this hair thickening. It's a ploy. It's interesting, as Pat pointed out, that the move to get basically the sentences dismissed and a call for a retrial, that motion was based on something that is absolutely legal, and the judge went so far as to call it harebrained. It appears to everyone that this move to request the drug treatment is just a move to cut a year off the sentence. That's all it is. For the former governor now to admit that he had a drug problem when it's never been alleged before, possibly he could have blamed his bad behavior on drugs earlier and possibly gotten a more lenient sentence. It's a game. You get better housing. You are coddled more. You get a year off your sentence. You're taken care of. Somebody waits on you and makes sure you're okay. That's not going to be the case when the governor checks in March, but the Federal Bureau of Prisons gets to decide. I can't believe that there's any way in the world, unless there's something that we really don't know about, any way in the world that this will be granted. It's just it's like all of the ploys that anybody can possibly think of. They have clerks setting up overnight looking for things that they can file to try to shorten the sentence, or heaven forbid that we would have to go through another retrial. It's a game, and it appears that Judge James Nagel is now tired of it, and I suspect that the Federal Bureau of Prisons will be tired of it as well.
I want to mention, just in case people are wondering, there's been no public revelation of what that drug problem or alcohol problem might be. It's not been part of the record in asking the judge for that. And for the record, I've always thought all the man needed was a haircut. His brain's obviously overheated, and it has probably caused this whole thing.
Well, we do know he's a Cubs fan, so obviously he's on drugs. There's part of it, bro.
Is there any way he could be on drugs and we not know it, considering the media scrutiny he was under, considering the number of enemies that he developed in Springfield and Chicago as time went on? Would somebody not have spoken up and said there's an issue here?
Well, if you suspected somebody was on drugs, what would be the first thing you'd notice? Would it be possibly erratic behavior, or illogical thinking, or zany
Oh man, that boy's hooked.
I've never heard anybody seriously suggest that drugs were the cause of his erratic, eccentric, narcissistic behavior, but by God, he's exhibited a lot of signs that one might attribute to that.
We need to take a break. We've got more Metro Talk in a moment.
Hello and welcome to the Lewis and Clark Minute. Today we're going to check out the music program with Dr. Teresa Crane.
Have you always wanted to learn how to play the piano? Maybe you wanted to learn Beethoven's Für Elise. Or maybe you like a more popular style like Jim Brickman. Or maybe you like jazzy blues. You can learn all this and more right here at Lewis and Clark Community College.
This has been your Lewis and Clark Minute.
When you open a book, you can explore new lands, make new friends, and discover new adventures. There are amazing possibilities when you open your mind to reading. Explore new worlds. Read.
60-inch screen, high definition. Football season is coming up. You can watch it right here. What do you think?
I'll take it.
Huh? Yeah, that's what I'm talking about.
You're right. I don't need it.
You're watching Metro Talk. I'm Kent Sheffel. Pat Gowan and Jim Schrader here. Jim, Madison County Circuit Judge Barbara Crowder has returned some campaign donations. She was going to be hearing asbestos cases. The donations came from attorneys that were going to be representing asbestos clients. Should those donations have been accepted in the first place?
Well, let's back up to say that Judge Crowder, who I know and know very well, or pretty well, has sat on the asbestos docket for 2 years since Dan Stack, formerly in that position, stepped down. And there is nothing illegal about a sitting judge who is running for re-election accepting campaign donations from a lawyer. It is more than legal in the state of Illinois. It's not considered a problem. This one was considered a problem in that Judge Crowder set the docket for 2012, which are set months in advance, and the majority of the open slots for asbestos trials in 2012 went to 3 law firms. Apparently, unbeknownst to her, that same week, her campaign coordinator, who happens to be her husband, put out an appeal to area law firms reminding them that Judge Crowder is up for re-election in 2012 and asked him if they would be so generous as to make campaign donations. They did that week to the tune of $30,000. The timing there looked really bad because it appeared, well, we got some of the choice slots for 2012. We've got, we'll line up clients to fill those holes, and as a quid pro quo, we'll make a nice donation to the judge that supplied us with these slots. I absolutely don't think that Judge Crowder knew that was going on simultaneously. Had she received those same donations 3 months from now, okay, people might say, okay, why are lawyers financing a judge's retention campaign? But there wouldn't be the appearance of the quid pro quo because the timing was so close. It was literally the same week. I think Judge Crowder had no other choice but to return that $30,000 just to shun that appearance of impropriety, even though Judge Ancalis and the other judges decided to remove Judge Crowder from the asbestos docket just to alleviate any potential appearance of impropriety. I think Judge Crowder did the right thing. She returned the donations. I don't think she knew that this was going on, and I don't think that there was a quid pro quo. I just think it was bad timing. In the meantime, her husband, who was her campaign manager, has relinquished those duties as well. Judge Crowder claims that her campaign committee works at arm's length from her, and she really doesn't know what their fundraising activities are. I think this was just bad timing, and it looked bad, so she did the only thing that she could do.
Pat, Circuit Judge Barbara Crowder accepted funds from attorneys that were going to be bringing asbestos cases before her. That money has since been returned. Should she have taken the money in the first place?
Taking the money from trial lawyers immediately after having assigned them trial times, although in a process that, while itself is controversial, I guess there's no real controversy over the way she apportioned that. They got what they pretty much always get. The timing of that was so bad that before I knew her husband, Larry Taliana, had solicited the donations, I wondered whether somebody was trying to set her up, whether these very law firms were trying to torpedo her. They didn't like her, and they thought, well, this would be one way to get rid of her. We'll lavish her with largesse that'll kill her at the polls. I had no reason to suspect them of that. I'd probably fine people. I was just grasping for some explanation for what's happened. The timing is so bad, the situation is so blatant, it's impossible for a rational person, I think, to believe that somebody was trying to get away with something when all this happened. Now, what's occurred is she may be afraid to take any more money from these firms. They may be afraid to give her any more money. Unlike other candidates for office, a judge runs for retention. She'll run in November 2012. 60% of the voters have to say, yes, we ought to keep her. The problem with running as a judge for retention is if I'm running for an elective office, I know if I have an opponent. And if I have a strong opponent, I know what to expect. If I have no opponent, I know what to expect. Somebody can be waiting for her out in the tall grass and pop up in mid-October with who knows what that she might need to answer with campaign money. So she may need a load of money come November. She might not need a cent to get retained. That's the ambiguity of being, the uncertainty of becoming, of running for retention as a judge. So this may hurt her ultimately in her ability to raise money, because people are going to shy away from giving it, and she's going to shy away from taking it. And whether anybody's going to be waiting for her in November 2012 or whether it will be forgotten by then, we'll have to wait to see.
We need to take another break. We've got more Metro Talk right after this.
Hello and welcome to the Lewis and Clark Minute. Today we're going to check out the radio broadcasting program and WLCA with Mike Lemons.
Have you ever listened to your favorite radio station or your favorite disc jockey and say, you know, I could do that? Or maybe you're the type of person who says, I could never do something like that. Well, with the help of first-year Mass Comm student John, we're going to show you just how easy it is. Each voice intro starts with talking about the band that just played, and we add a station identifier. Next, you want to offer some information that may be of interest to your audience. And finally, tell the listeners what the next song is, who sings it, followed by another station identifier. John will do one live now.
Silver Sun Pickup substitution on WLCA. The Big Pink released their debut album called A Brief History of Love. The single is off that album. It's The Big Pink with Dominoes. It's on College Radio's Best 89.9.
This has been your Lewis and Clark Minute.
What's that? I don't know. Something I kind of made.
Ooh, what's it do?
What do I do? Well, thanks for asking. I ring my bell and I like to dance. What do I do? Well, thanks for asking.
Ow!
Yeah, it still needs a little work.
Anything's possible. Keep thinking. Get started on your own inventions or just play some games at inventnow.org.
Sounds like you could use some Van Gogurt. It's fortified with arch-rich nutrients to improve your math and reading skills. Catch!
Van Gogurt, thanks. So what's the deal with your ear?
Always with the ear, huh?
Feed your kids the arts. For 10 simple ways to learn how, visit AmericansForTheArts.org.
You're watching Metro Talk. I'm Kent Sheffield. Pat Gowan and Jim Schrader are alongside. Pat, we were talking about the court system in Madison County. Word has also come out from the American Tort Reform Association that Madison and St. Clair counties are now back on the list of judicial hellholes, ranked 5th worst in the nation out of a list of 8. The bottom line is, are we going to be able to get off this list, or is it a problem that we're on this list?
I think we want to get off the list. This is a pro-business lobby group that puts this out. They use very strong language to suggest that plaintiffs have a great advantage in Madison County courts, which means one guy's hellhole is another guy's paradise. If you happen to be a plaintiff, if you happen to be an asbestos plaintiff perhaps in Madison County Circuit Court, it may not be such a bad place to be. So the question of whether it's a hellhole depends upon where your litigation falls into things. I haven't seen anybody prove to me, or even make any particular case, that case by case things are treated unfairly, that defendants don't get a fair shake. We're not really hearing that. I don't know whether Jim's people are hearing it. We're really not hearing that. What happens is you've got a very active plaintiffs' bar that's built up, people who press the asbestos cases. There are estimates that as many as 1 in 6 asbestos injury cases in the country are tried in Madison County because there are specialists in Madison County who bring the case into their courts. You know, if you want a good shot on an asbestos case, go to one of the 3 firms we're talking about who gave money to Judge Crowder. So with that in mind, they're particularly wrangled by the idea that all this litigation is being brought here. They say it's a burden on the taxpayers. I don't know about all that. All I know is there are 2 sides to that coin. The other side's never really quite as loud, but essentially the trial lawyers and the people who don't have the aggregate of money as business, because plaintiffs tend to be individuals and business tends to clump together, you know, to spend its money. So there isn't a plaintiffs advocacy group that wants to raise its head. That would be the trial lawyers, and their target's enough as it is, so they keep their head down. So this goes pretty much unanswered, comes along every year. Draw your own conclusions about whether it's a hellhole or not, but I think it's gotten to the point of almost being silly.
Jim, Madison and St. Clair counties are back on the list of being a judicial hellhole. Is that a problem? Should we get off that list? Does it make a difference?
Well, as Pat pointed out, the people that are labeling it a hellhole have their own motives for calling it that. If you look through the 77 pages of yellow pages, the local yellow pages, and looking up attorneys, certainly the vast majority are plaintiffs' attorneys. There's all kinds of half-page and full-page color ads saying, if you've been hurt at work, call me, or if you've been affected by asbestos, call me. You find very few lawyers in Madison County, usually with offices in Edwardsville, not far from the courthouse, that are willing to take on the companies, the defendants, many times, which forces corporations to go out of town for their representatives. This is not a new allegation against Madison County. Everyone should remember that there was this circuit riding lawyer a few years ago named Lincoln, who made a name for himself in Madison County suing the railroads, some of which didn't even have tracks in Madison County. Mr. Lincoln did a pretty good job with that. Had an office in Alton, had an office in Edwardsville, had different offices around, and he rode his lowly horse back around and did pretty well for himself suing the lawyers. It's not a new claim. We're no longer number one. We've slipped to number 5. I think a jurisdiction maybe in Texas may have crawled up to number 1. And again, it depends on which side of the lawsuit you are, whether or not you're a hellhole.
Another thought about that I ought to mention. St. Clair County, by the way, is a hellhole too, according to these people. I think there are 30, I'm not sure, 37 or 36, something like that, counties in the 5th appellate court district in Illinois. All the appeals from all those places go to the appeals court in Mount Vernon. That includes the cases appealed from the hellholes. That includes the cases from the vast number of those counties which have not been labeled hellholes. So the oversight of the cases, if you take an appeal, you've been treated unfairly by the courts, it goes to the same appellate court as all the other non-hellhole counties, which means there ought to be some equalizing effect there. And by the way, I never see them list the appellate courts as hellholes. And if the appellate court's not a hellhole, I would think it would probably be able to rectify some of what's allegedly wrong with the hellhole courts in Madison and St. Clair counties.
Pat, an investigation into a 2010 accident near Six Flags has led the National Transportation Safety Board to call for a ban on the use of cell phones in a car. Is it time to get rid of cell phone use completely while driving?
Well, the accident killed 2 people, including the driver who was texting. It injured 38 people, and it made a very strong point. It was illegal for him to be texting. If you're going to make it illegal for people to use cell phones, you got to be able to enforce the law. There was already a law against what he was doing when he caused the accident, and that didn't stop the accident from happening, and I think that's instructive. I don't think we should have a specific law that says you can't put on lipstick. I've seen people do it, or read a book. I have seen that, I swear to God. Or read a map, or read a newspaper, especially read a newspaper. That's a good thing to do at any place. Why making specific acts illegal seems silly to me. What you ought to do is maybe incorporate some greater specificity into the reckless driving law. And if I'm all over the road because I'm texting, or because I'm talking on the phone, or because I'm changing the CD, or any of a million other distractions, then ticket me for reckless driving, as rightly you should. But I don't think the act of talking on the telephone per se is that distracting. And I've always been a big safety advocate, but I just don't believe that. I think if you've got half a brain, you can carry on a telephone conversation. Certainly hands-free conversation, as easily as you can have the hands-free conversation with the guy that's sitting in the seat next to you, or the people in the back seat. So the next thing maybe is you can't talk to anybody inside the car, or can't listen to the radio inside the car, because these things are all proven distractions. I think you put the force of the law where it makes sense. I don't think that part of it makes sense.
It's absolutely feel-good legislation. Well, we're going to save lives by cracking down on this. You can't do it. There are too many other potential distractions. Pat, enumerated several of them. Eating a burger, driving with your knees, talking on the phone, texting, changing the CD, changing the radio, moving your seat, talking to your kids in the back seat. I mean, this could go on, smoking a cigarette. I mean, there are all kinds of things that lead to distracted driving. This unfortunate individual out by Six Flags was already breaking the law. Obviously, it didn't stop him. There are people that are still driving around with no seatbelts. It's against the law. They're going to do what they're going to do. It's just the way it is. Unless you make the technology that blanks out your electronics when you get in the car so that you can't take or receive phone calls, which good luck getting that one to stick, right? We're also dependent on that. It's just not going to stop it. I have a whole lot more trouble in the morning, especially coming to work, watching, as Pat said, people putting on makeup. They're leaning up against their mirror and they're putting on eyeshadow and so forth. That to me is just as distracting, if not more so, than me talking on a Bluetooth that's hanging in my ear. I'm not touching my phone. It is voice dialed. It is voice actuated. And, I'm not reading a laundry list to Santa Claus on the phone. I may have to conduct business on the telephone. But there are too many ways for distracted drivers to be so distracted that they cause an accident or are involved in an accident.
You ever ride beside somebody who dropped a cigarette in his lap? You know where the #1 priority goes? It isn't the driving.
No, where is the #1 priority?
And I'll tell you something else that I think is probably more dangerous than somebody talking on a cell phone going down the road, and that's someone talking on a cell phone going down the road trying to hide the fact that they're talking on a cell phone going down the road, because that's going to be a natural consequence of this too. I am in favor, by the way, it's against the law in Illinois to use a cell phone in a construction zone for the driver. I'm behind it. I think that makes sense. I think that is a special driving condition. It's not a hardship for people to do that. I do believe in that. I think some restrictions do make sense. It's just don't throw it all out willy-nilly.
Well, your car, my car, I suspect your car, you can hook your telephone that you can talk through your speaker system, and you never have to lift it off of your belt or out of your pocket.
We don't all drive high-end Mercedes. I want to
No. I mean,
very clear.
I mean, you can talk about a Ford Fusion that has that technology. These are not high-end, expensive cars. All of that technology would go out the window pretty quickly. Mine is a little $39 Bluetooth earpiece, and to call someone, I can push the button on the earpiece and say, "Call Pat Gowan," and it dials. How it works? I don't know, but it does. It's amazing. I personally don't need glasses to drive, so I couldn't text anyway because I do need glasses to read. So I'm better off just making the phone call.
Pat, Senator Dick Durbin wants to put a 2% surtax on anyone earning over $2 million a year. He wants that amount over the $2 million taxed at a 2% rate. Is it time for a surtax on the wealthy?
I think it bears consideration to put a surcharge on the income of anyone who earns more than I ever expect to earn.
Which would include anybody making $2 million a year.
Yeah. Yes, it certainly is. In fact, you could even lower that a little bit and I'd be okay with it.
If you add up everybody in this room, we don't get to $2 million a year, guys. Well, that's true. He works for the state.
It's fundamental to the emerging debate of who has to carry the financial weight in this country. Is the United States shifting toward a government that favors the rich or not? And I think that's the background against which this has to be framed. Now, maybe you're not favoring the rich by not adding the tax. You can debate this endlessly, but I think it is an element of that greater debate that's going to increasingly be taking place in this country.
Jim, is it time for a 2% surtax on any earnings above $2 million, as Senator Durbin wants?
I don't know how we're going to pay our bills in this country. I don't know how we're going to pay our bills specifically in the state of Illinois. I certainly don't know how we're going to pay our bills nationally either. I guess the simple answer is you tax the people that have the money. It doesn't do any good to tax the people that don't have any money. This is going to cause Senator Durbin some real problems down the road because the rich are not going to like it. But you can't tax those that don't have anything to attach.
That's going to do it for this round of Metro Talk. Thanks for being with us. Pat Gowan, one of the editors with the Post-Dispatch, has been here, along with Jim Schrader, the publisher of the Telegraph. I'm Kent Scheffel. Enjoy the holidays.
Merry Christmas.